7421761 or 7421962.
Except he's sick of coming to work today.
I've already put in my notice, so technically I could just walk away.
Yeah, but you would like those 23 days of pay, wouldn't you?
Not really.
Oh, okay. Well, in that case,
Although my next check does have $250 worth of tips on it.
I was messing with
Anybody got any extras in?
some of the stuff that you had sent me, and I noticed
You
one
do share.
Who are the
it has authors, and it says
trial
Jacob Rangel.
arguers? You are? Okay.
and me.
So come on up and have a seat in the orange chair, the council chair. So you will be ready to go.
A couple of y'all might want to scoot in a little further so if they've got like throw note cards out.
Beware the man with a binder.
Yes, I know.
Do you need to volunteer court reporter?
Well, apparently you guys-
I'll do it.
Pretend like
Do you get extra credit? Really?
There you go. Yeah.
Yes.
There you go. Come right here.
Okay, if they ask you to repeat what they said, you better be ready to.
Can you read that back to us?
He goes, wah, 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 wah,
A little too excited.
You look like
What is that? What is that supposed to mean?
the judge. Make it a all right.
He's gotta record.
And we will also have a video.
Did you start the video?
Yes.
Well, we should put the camera facing this way.
Unfortunately,
I better
that's.
get my solitaire up on the screen so I look like I do.
I think I've designated.
Made a crossword puzzle.
Where's the guys?
Correct.
That deals.
Oh, that's what they should.
Cher, we actually need you to pay attention, so I'm sorry you can't do that.
What did I just type?
Blah, 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 blah.
Yeah. Give you a hint. Second word's you.
Does the first word rhyme with yuck?
All right, the court will call for pretrial hearing case State of Major versus Edward Taylor Hard. Is the prosecution ready for pretrial hearing?
Prosecution's ready, Your Honor.
Is the defense ready for pretrial hearing?
Defense is ready.
Make sure you stand up and address the court. Forget.
Defense was ready.
There you go. All right. Okay, we'll take up the prosecution's motions, pretrial motions to begin with. And so, which motion do you want to present first?
We're actually, the prosecution, Your Honor, requests to withdraw our motion in limine regarding speaking objections and sidebar remarks.
Okay, do you have any objection to that motion being withdrawn?
No.
Okay.
Your Honor, the second motion we would like to discuss this morning is our motion in limine regarding clinical diagnosis of pneumonia in regards to no sidebar comments, presentation of evidence, etc. We believe that the illness of pneumonia is completely irrelevant to the matter at hand, which is the murder of Breno Summers. The pneumonia was a direct result of the gunshot wound, and we don't feel that this has anything to do with the actual matter at hand.
All right, do you have any response?
Yes, I do.
Defense? All right.
Do I need to stand up?
Well, yes.
Okay, while defense agrees that the pneumonia was a direct result of the gunshot wound, there is a Rule 107, the Rule of Optional Completeness, and that mentions if you're going to use a document, then you have to include the entire thing. And there's no reason to hide it from the jury. It seems as though we're trying to hide it, and I don't feel like that's in the interest of justice to do that. That's all.
Do you have anything further?
Well, we simply just feel that the whole matter is irrelevant with the pneumonia simply because if Summers would not have had the pneumonia if he had not been shot. And ultimately, the gunshot was going to cause his death one way or the other. The pneumonia is just a sideline.
Anything further from the defense on that motion? Okay. All right, I'm going to grant the motion in limine before you, if the defense intends to offer that evidence, you'll need to bring up to the attention of the court outside the presence of the jury during the trial before you offer that. Okay.
Our next motion, Your Honor, is in regards to the evidence regarding the knife and neo-Nazi paraphernalia that has to do with Bruno Summers. We feel that the knife is irrelevant. There was no proof that the knife was ever opened. It was never used as a weapon, and the knife was found in the jacket pocket of Bruno Summers folded. The knife was not an issue in this matter. As far as the neo-Nazi certificate, the certificate is prejudicial and irrelevant, and we feel that it's irrelevant because neither the victim nor the defendant were of a race that would have been affected by the nature of this organization listed in the certificate, and we feel that it is prejudicial. Under Texas Rules of Evidence 403, we do fear that it would confuse the issues and mislead the jury.
Okay, any response? Vince?
We don't have any argument with the Nazi certificate, but for the knife, under 401, we think it's very relevant. It goes to our client's defense, the affirmative defense, and we need that for that reason.
Once again, Your Honor, the knife is still irrelevant. The knife was on his person, closed. It was never taken out of him. No witness ever saw the knife.
Well, the question here on the motion is whether or not we should bring this up outside the presence of the jury for a ruling prior to offering the evidence. And for that purpose, I'll grant the motion. Doesn't mean that these aren't going to be admissible at the time of trial. It's just we have to bring that up outside the presence of the jury if you intend to offer either one of those items.
Thank you, Your Honor. The final one is we have requested a lesser included offense in the jury charge. We are already aware that the court has included manslaughter. We're also requesting aggravated assault with deadly weapon under Texas Penal Code Article 2202. We do believe that the incident offense meets the element of aggravated assault with a deadly weapon as well.
Okay, any response for the?
We don't have any argument with those charges.
So you don't object to lesser included offenses of involuntary manslaughter or aggravated assault? Do I understand you correctly?
Yes, yours.
Okay, that will be granted, and we will include those. Let me ask this question of the prosecutor. Mr. Prosecutor, what are the differences in the elements between involuntary manslaughter and aggravated assault?
In the case of aggravated assault, it's simply an assault that a bodily injury occurs. We'd like to point out that our victim, Bruno Summers, was injured. Of course, he would later die as a result of the incident that occurred. However, the only real difference that we've been able to see is that manslaughter is causing the actual death of the individual, whereas aggravated assault shows bodily injury. Bruno Summers was injured as a result of this incident, regardless of whether or not he died.
When you say involuntary manslaughter, do you mean voluntary manslaughter?
I'm sorry, I apologize, Your Honor. In the case of voluntary manslaughter.
Okay, well, your motion says involuntary.
Okay, well, I do apologize for that, Your Honor.
So which is it that you're requesting, voluntary or involuntary?
We're actually going to request involuntary manslaughter.
Involuntary. Okay, anything further? from the defense on
The
that?
defense would ask that that be dismissed because it was incorrect in the original pleading that we received.
And we would ask if
Okay,
that's
well,
probably,
as I understand it, he's asking that involuntary manslaughter be included as lesser offense. Not voluntary, but involuntary. Did I understand correctly? That's what
What's
the
that?
motion.
that is what our motion shows is involuntary. I misspoke.
Well, I think that's what you said, but I want to make sure I understood.
Yes,
You're asking for involuntary and not voluntary.
We're asking for involuntary.
Involuntary. Do you have any objection to that?
No.
All right, so that'll be great.
We have nothing further on it.
Okay. Okay, defense, you have some motions you want to present?
Right, the issues that we'd like to discuss first would be the mentioning of the .22 caliber gun that was recovered on the defendant Edward Hard because it was retrieved from his home and that was a violation of the Fourth Amendment rights he has. So that shouldn't be brought up
So
unless,
you're alleging that there's a search and seizure issue with regard to the gun.
yes,
And you're asking that we have the motion limited be granted on that.
yes,
Now, this is not a motion to suppress. You're asking that this be brought up during trial, outside the presence of the jury, that you intend to object to it, and at that time, offer evidence of why it should not be admissible.
Let's just withdraw that one.
You
With
withdrawing
regard to the
motion
gun, with
limit?
regard to the
No,
gun, excuse me.
Does the prosecution have any objection to
We
the
have no
motion limit?
objections, Your Honor.
Okay, we would like to, the prior criminal history of Edward Hart, we don't want that brought up in any way. It's prejudicial. It's more prejudicial than it is probative, and it's not relevant.
Your Honor, the prosecution finds that this shows that the defendant does have a history of violent acts and inappropriate behavior. We feel that this is absolutely necessary to show the jury that in fact that this person was and is capable of such an act.
Okay, anything further?
The specific acts that someone has committed prior to, they have to be similar in nature in order for it to prove or be relevant in any case for the act or the crime that's being charged today or at trial, and it's not relevant. They're not even similar in nature, so that I don't see how that would be relevant.
Okay, again, all these things you filed under motion limiting, so you just have to bring them up outside the presence of the jury, if you're going to object to.
Okay.
All right, third, you had the statement taken by the police during interrogation.
We were simply arguing on that he was intoxicated, so his state of his state of mind was altered. Not necessarily that should be brought up.
Okay, are you saying that his confession was not voluntarily made?
We're saying that it is not reliable.
Your Honor, the prosecution would ask that this would be allowed in. The detective asked the defendant multiple times if he would like an attorney prior to questioning. The defendant refused multiple times. In addition, he also signed a waiver of his rights.
Okay, and again, it's just a motion limiting. We're not making a decision on admissibility
Oh.
at this point. These are motions limiting to bring the points up that these will be matters during the course of the trial that you'll need to bring to the court's attention as to whether or not this is admissible if it's offered by the prosecution.
Okay, withdrawn.
But you want them to bring it up without having to bring it up before the outside the presence of the jury?
They can. No, it doesn't necessarily need to be outside the presence of the jury.
And we want them to hear about it, and what if they hear about it and then I rule it as inadmissible?
Okay, outside the presence of the jury.
Yeah, that's motion limiting.
Okay.
Is that what you're asking for?
Yes.
Okay, the fourth thing you have here is statements constituting inadmissible hearsay. So on the four things of your motion here, as far as the motion limiting is concerned, I'll grant the motion on all four things. Just means if the prosecution offers any of these items and you object to them being admitted, okay, we'll need to do that outside the presence of the jury. In other words, the prosecution is instructed before you offer the gun or the criminal history or the defendant's statements or anything, it's inadmissible hearsay. But if you offer any of those items, if you intend to offer those items at trial, we need to bring it up outside the presence of the jury first to get a ruling on admissibility before it's offered to the jury.
Okay.
All right, so I'll grant that as to the things.
That's all.
Okay, let's see, I had another motion here, request for notice of state's intent to use evidence of extraneous offenses under Rule 404B.
Right, that would actually be included in number 5 on the original, lacking personal direct knowledge are evidence.
Okay, well,
In
number
that
5
notice.
doesn't cite Rule 404B, but this is a notice that you've given to the prosecution. You've asked for a written notice prior to trial of their intent to offer evidence of extraneous offenses.
Okay, yes.
Okay, so that will be granted, which means the prosecution needs to give written notice of any intent to offer extraneous offenses at least 10 days prior to trial. We've also included in there a motion for discovery. Do you have anything you want to argue on that?
We would just like it to be granted.
Your Honor, at this point, all the items that should have come out have already come out. Therefore, granting this motion is totally.
Okay, so you complied with their request for discovery, is what you're
That is correct.
Okay, all right, that'll be granted. All right. We also have another motion here to reveal witnesses and extraneous offenses. The extraneous offenses we just talked about. All right. And you're asking, you actually have two motions for discovery of witnesses.
By this one, actually, we would like that to mean the actual real witnesses that they're using,
As opposed to
as opposed to the ones like in the kit, like the ones from the class, the volunteers.
And Your Honor, at this time, we don't know who those individuals are, and we have no information.
Okay, the only thing I'm gonna order to be provided are the names of the witnesses as they're going to be
Which we already
testifying as characters in this trial.
Okay.
I'm not gonna order them to give you the persons who are playing those witnesses, their names, address, or information.
Okay.
And that's for both the motions here. One is, I guess, the witnesses who will testify, and the other is all witnesses to the event. So, and that, it's for both motions. I'm gonna order the state to give you the names of who they're gonna call as witnesses at the trial, but not to give you the names and addresses, or
Okay.
contact information for people actually playing those parts. So be granted in part.
Okay.
All right, anything further from the defense?
No, we rest.
Okay, anything further from prosecution on pretrial?
Your Honor, we just need clarification did you officially accept the withdrawal of the statements of the police investigation about the defendant being intoxicated?
Well, I've granted the motion in limine.
Okay.
Now, that doesn't address the admissibility of those matters. That'll have to be a matter that's brought up during trial.
We have nothing further.
Anything else?
No.
Okay, I will issue pretrial order number 2, probably get you that next week with our rulings on these matters, and if there's nothing else, then we're concluded for today. Court's adjourned. Thank you, Ms. Court Porter, you did an excellent job.
I'll take this and type it all up.
I got the feeling you were really fine.
Like, I really don't know how these keys work.
Give that girl a raise.
I don't. So that ends this session of Court TV.
Yeah, it's the law. Will you keep a copy of this? And then she's got this, here's your type up. I will.
Okay, we have one more thing to discuss here. And that is the last chapter in the book.
I thought we were done, we were on
We're
getting
not
ready to
done.
leave.
We're gonna talk about closing argument. Who's gonna be doing the closing argument?
Yolanda.
Yolanda. All right, what is the purpose of closing argument? Closing argument?
To summarize and wrap up your side's case, persuade the jury to rule in the.
Okay, yeah, to persuade the jurors, right? To persuade the jurors that the evidence has shown specific things. Whatever you told them it was gonna show on your opening statement, you need to show them or remind them or explain to them how the evidence has proved that. So the person that's doing the opening and closing need to talk to one another, and they need to be coordinated. Right? So if in the opening statement you say the evidence is going to show this, and in the closing statement you better say the evidence showed this, and here's the evidence that shows that. So you want to coordinate those two. They have to make sense. Because if you promise to show them something on opening and you don't show it to them, they're going to hold that against you. All right. What else? What are some other purposes of closing?
Kind of summarize your case.
Okay, summarize the evidence.
Explain to the jury further after what they've heard already, what they need to what you want them to consider from your side.
Okay, and who goes first on closing argument?
Prosecution.
Prosecution, the party with the burden
Right.
of proof, right, in this case?
Right.
Okay, and then who goes last?
The defense.
Yeah.
The same party,
It's
right?
the same
They get to
prosecution.
do rebuttal argument, okay?
Last.
All right. So when do you start planning your closing argument?
Now.
2 weeks ago.
Yeah, way before you get to the trial, right? Not during the trial, okay? Now, can you say, I think the evidence showed this?
Yes.
No. You can't tell them what you think it showed. You can say the evidence, we believe the evidence showed, you know. Okay. You really want to say, you should find that the evidence shows this.
Oh, I understand.
Okay. You can make reasonable inferences and deductions from the evidence. well, evidence showed this, so you can infer this happened. Okay, that kind of thing. All right. The other thing you want to do in closing argument is respond to the opponent's arguments. Okay, so and you may not know exactly what they're going to argue until you hear their closing. So you have to leave yourself some room in your closing argument to respond to their closing arguments. The prosecution argued this. This is why that's wrong. Okay, so you want to leave yourself some room and some time to do that. All right, there are a couple different approaches to closing arguments. One I call a classic or traditional approach. That's the boring approach. That's not the one you see on TV. That's the one you see on the real court shows where they stand up and they say, "Thank you very much, ladies and gentlemen, for your jury service. The jury is a very important part of our justice system," yada, yada, yada. You know, the jury wants, get to it, okay? And then they remind the jurors, you remember you were sworn an oath to find from the evidence the truth and, to follow the law exactly. That's exactly what happened. Okay?
You shouldn't call it the board.
Right. So you're trying to avoid that kind of closing argument, right? Get right to it. The evidence showed this or whatever. Or we told you on opening this is what's going to happen, and that's what we showed, whatever. Okay. But focus on the key facts that are in dispute. Don't waste time on the things that haven't been disputed. If there's no dispute that Bruno Summers was shot and died as a result of the gunshot, don't spend time on that on closing. You're not arguing that. You're arguing other issues. So focus on what are the key issues that are in dispute. But don't ever say the facts are undisputed. Because if they're undisputed, you wouldn't be there. It wouldn't be a trial. That's why we're a trial. Because the facts are disputed. But I've heard lawyers get say, "Ladies and gentlemen, the facts are undisputed here." The other yeah, they are. We're disputed. That's why we're here. So don't ever say things like that. Be careful what you say to the jury. Okay. Can you argue the law or the facts or both? No, just the facts.
Right?
Just the facts. You cannot
The law
argue
is
the
the
law.
law.
The law is what the judge gives the jury in the jury charge. This is the law. And you cannot say the law is different than what the judge says. Okay? The judge gives the law. So you have to follow the law. And so you need to make your facts fit into the law. Right? Okay. We are bound to follow the law. So we can only argue the facts. Discuss the evidence that proves your facts. Discuss how the law applies to the facts. Okay? If the law is this, here are the facts, and here's how it goes together. All right, you want to make sure that you are credible. How do you make a closing argument that is credible?
Don't say something that you didn't
Give them a MasterCard.
prove.
Yeah,
Or
don't
argue.
argue something that evidence did not prove and say that it did. Okay.
Present, don't attack.
Yeah, don't attack the jurors, especially don't attack the opposing counsel. You say, here's why we're right. Okay. We just got done with a 1.5 year negative presidential campaign. Don't be negative. Be positive. Be simple. Keep it simple. The jurors are simple people. They weren't smart enough to get off jury duty. Remember, all they had to do was raise their hand and answer questions. They weren't that smart. What? Did you have jury duty? No. Oh. What? Go ahead. What'd you say, Sarah?
Uh-oh. I don't even know if she heard the whole thing.
No.
I was really nervous before the pre-trial, and I was like, I don't feel good. I think all that nervousness made me sick.
But at first, I thought she said all that nervousness made me fussy. And I was just like, I was like, I'm sorry, what? Okay.
Be logical. Make sure that your argument makes sense logically. Don't forget your theory of the case. You might want to start out with a theory of the case. What is your theory of the case? So, use visual aids. That's fine. Okay. Be positive about your burden of proof. If you have a burden of proof, the prosecution has the burden of proof in the case on the elements of the offense. Here's maybe a checklist. Here are the elements of the offense. Here's the evidence to prove this element. Here's the evidence to prove that. Here's the evidence to prove that. If you're defense, you're arguing self-defense. Here's self-defense. Here's why it shows that. Okay. But you also have to deal with the weaknesses of your case. You have to acknowledge that, yes, it's not the best case. You may have questions about this or something, and here's how you can resolve that. So, for example, why would a 16-year-old not tell the police everything the first time they talk to him?
Scared.
Yeah, lots of reasons. There's lots of logical reasons, explanations for things. So if you run across something that's a weakness, address it. Okay? Address it in your closing argument. Why would a person do this?
Okay, I have a question.
Sure, go ahead.
Okay, if we are going to address it in closing that way, do we address it with a theory that we've come up with? Or,
You would address it in a way that's consistent with the evidence,
okay,
or with the jury's life experiences.
But we don't get that opportunity with their life experiences. We don't get the question.
Well, just jurors and people in general. I mean, life experiences, just sort of general kind of way.
can we do it in a definition way? Like if we have a definition that we really want them to understand, if it's gonna prove our case?
Sure.
Okay,
Could you
But
kind of,
you can't remember. You can't argue the law.
right,
Yeah.
it's not arguing the law. It's like if there's, okay,
Use analogies. Say this is like this situation. The jury can
Okay.
understand. Yeah.
would you or could you recap or explain to them the burden, like reasonable doubt? I know you said that prosecution.
But why do you want to waste your time talking about the other side's burden?
Well, just to say like, this doesn't match up and this is why it's doubtful.
Okay.
Or this is why you would have a
All right.
reason to doubt.
You can argue. Yeah, you can argue the evidence does not meet their burden of proof. Sure, that's fine. You don't want to spend time explaining their burden of proof.
Right.
You say, the state explained to you they have the burden of proof in this case on these elements, and here's the element they didn't prove, and
Right.
there's no evidence that shows this. You can argue that. Sure, that's you're
Okay.
arguing the facts. Exactly. That's fine.
But can we say the fact that, because I guess that we want to emphasize the fact that there's gotta be doubt, the doubtful fact, because this element is what causes the doubt.
Well, you would say, the state failed to prove this element of their offense, and that's why there's a reasonable doubt.
Doubt, okay, good, that's what I'm asking, yeah.
You should have a reasonable doubt here because.
Yeah, that's what I'm asking, okay.
Refer to the opposing party. Refer to the opposing party, not the counsel. You don't want to say,
The government,
yeah, you're referring to the parties in the case, not the.
these folks,
Don't say,
these guys.
Yeah. It's not.
The two youths.
It's not. Mr. Height argued this. It's the state, right? It's the party. It's not the council. So it's not. Mr. Gonzalez argued this. It's the defendants argued this. So don't use notes. You should have your and again
Thanks, Braille.
3 points. 1, 2, 3. 3 things you want to talk about. Just get up and talk about. Ask the jury for what you want. Explain why it should be the verdict. We want you to find the defendant not guilty. We want you to find this or that. And this is what the evidence. This is why the evidence shows that. Style of presentation should be relaxed. Make eye contact with the jurors, except for Matt. Be understood. Do not be distracting. Don't wander around, spin around in circles.
Eye contact.
That kind of stuff.
No dancing.
Don't hide behind something.
Hold on, smells.
You're going to stand about the same place as you did on opening, during closing argument, in the front of the jury, and make the argument to them directly, appeal to them. A couple examples. In a criminal case where the prosecution has to call an unsavory witness, the defense might make the following argument. If you find a maggot in your food, you throw it away. The prosecution here wants you to ignore the maggot and eat the rest of the plate anyway.
Nice.
How about that? That makes an impression. They
Gross.
go, oh, yeah, right? That one witness was horrible, but should we believe the rest of their story now? Okay. If your case involves largely circumstantial evidence, you might make the following argument. Imagine you're at home just before going to bed. It's clear outside. The next morning you woke up, look outside, and see the lawn is covered with snow. You didn't actually see the snowfall, but there's no doubt the snow fell down. That's circumstantial evidence, right? That it snowed.
What other would have been the other? I don't get that.
not there. It's not.
Well, it would only be direct evidence if you saw it snowing,
Oh,
but you didn't
okay.
see it snowing.
Okay, but you didn't see
But
it.
you know it's not.
But
But
you
you
know
know
it's
it snowed because there's snow there.
That would be
Oh,
possible.
okay.
You can't argue,
I
hey, it
thought-
didn't snow last night
No, that's not how I
because
was.
I didn't see it.
That's not how I was interpreting what you were
Right.
saying, so
That's what I was saying.
I get you.
As plaintiff in a personal injury case, you might argue, you're probably saying to yourself, Mr. Jones, that's a lot of money you're asking for. Why should you be awarded $300,000? You're right, of course. This is a substantial sum of money, but in this case, Mr. Jones' injuries have been devastating. You know, put yourself in the place, what's the jury thinking? And then usually kind of a rhetorical kind of question. As a prosecutor in a criminal case, you might argue, in this case, the evidence showed the defendant just happened to be 1 block from where the robbery occurred moments earlier. Just happened to have a nickel-plated revolver on him. Just happened to have $47 in his pocket. And just happened to be wearing a red velour shirt. If he's so innocent, I'm sure his lawyer will have a great explanation for how these things just happened at the same time when he argues his case. Now, you can't really do that in a criminal case because that's changing the burden of proof. But you get the idea. Right? As a plaintiff in a personal injury case, you might argue, why didn't the defendant just keep his foot on the brake until the light changed? It was only 2 more seconds. Why didn't he just wait 2 seconds?
Twinkle.
Okay? That's the question they never asked or never wanted to ask it. And it's the only question that needs an answer. Right? Okay? A defendant in a criminal case might argue, where are the fingerprints? If Bobby was really the burglar, really ransacked that house, as they claim, wouldn't you expect to find his fingerprints all over the place? Or at least something. Where's one single fingerprint? Okay? You're raising doubt, right? You're raising reasonable doubt in a criminal case. All right? The first minute of your closing really should be trying to catch the jury's attention, okay, with your theory of the case. You know, tell them what really happened, according to the evidence, your interpretation of it anyway. All right? Don't forget to review the key instructions in the jury charge. You're going to have that already. They've already been read the jury charge. And so you can say the jury charged you that this is the law on this issue, and you know, here's why the evidence shows that. Okay. Don't forget, jurors have limited attention spans. I've given you each side 10 minutes. That's probably as much as you need.
And you said on ours, when
We split it, actually split it 50-50, or however you want to do it. I mean, if you want to do, if the prosecution wants to do 7 minutes in the first part, say 3 for rebuttal, whatever you want to do is fine. So however you just let the court know. All right, but the prosecution or plaintiff must present the entire argument in the first part. Okay, so you got to cover everything in the first part of the closing argument. Okay, rebuttal is to respond to the defendant's argument closing. Okay, rebuttal is not where you sit back and save things to argue at the end. Okay, you have to. That's only for responding to the defense closing. We've had cases here, I may have mentioned this before, but if the prosecution, it was a criminal case, a couple of criminal cases, prosecution got up, did a partial closing argument, didn't cover all the stuff that they intended to cover. The defendants waived their closing argument. Prosecution doesn't get to do rebuttal because there's nothing to rebut. So we just cut them at the knees. Okay. So in this case, the defense has to do a closing argument, so you're going to get through rebuttal.
Sorry, Amanda, you ain't gonna get that look yet.
How long should you do rebuttal? Well, only long enough to respond to the other side's argument. Closing. That's it. Just respond to what they said. Well, there are a couple of what's the advantage of going first and last? Okay, so closing argument.
You have a chance to set the foundation and then go back and like tear theirs back up.
Yeah, it's called primacy and recency. Primacy is what you hear first. You generally remember more, and the other one is what you hear most recently. You remember more. So what you're in the middle, you tend to forget. Kind of like class.
Because you're like this.
I remember.
Kind of
Might
like
as well
class,
just
right?
say nothing, right?
Okay, what you can't do on closing argument, you can't lie. You can't misstate the law or the evidence. You can't argue facts that have not been admitted into evidence. Now, you can draw reasonable inferences, but you cannot say these facts, if they're not admitted to evidence. Do not state personal beliefs. Not, I believe this. Don't do that. You can't vouch for a witness's credibility. You can't say so-and-so is credible, okay, because you cannot appeal to passion or prejudice, and you cannot argue irrelevant use of evidence. What if you say that the other side has presented a false case? Can you be sued for defamation? No, you're protected. Lawyers are protected from defamation during the course of arguing a trial. I can call anybody a liar, an SOB all I want, thief, whore, whatever. I can call them anything I want to call them, and I can't be sued for saying that if it's in the context of the trial.
Mr. Clerk, would you, on the prosecution side, would you remind the jury that they have a lesser included charge if that were the case?
The jury will be read the charge from start to finish. The entire
So
charge.
there's no need to state that in your closing argument?
If you want to argue that that's what the evidence proves, then that's what you can do, right? Yeah, you can do that. The court has charged you on the lesser included offense of whatever it is. The evidence, if you don't find that the evidence shows this, and you may find that the evidence shows lower, sure, you can do that. But it's hard to argue that the evidence shows both.
Yeah.
If you say, I guess the way to handle it is to say, if you don't believe that the evidence shows murder, then you may believe that it shows aggravated assault. Okay? I mean, you kind of got to be careful. You don't want to argue one or the other because they're mutually exclusive. You can find one or the other. You can't find both. Okay? So just be careful the way that you word it. What about complimenting opposing counsel? Can you do that in closing argument? Should you do that in closing argument?
Could you, in the sense that you said call them SOBs?
Can you like
That's a compliment?
backhand compliment them, like?
Unless you mean compliment sarcastically,
Yeah.
they did a great job of presenting you,
The
False
plaintiff's
false-
esteemed distinguished counsel over here argues this. What about doing that? Aren't you trying to set up a little David and Goliath kind of thing?
Yeah.
Like us poor little, and I've done this. Remember, ladies and gentlemen, the prosecution has the entire resources of the state of Texas in this case. Mr. Gonzalez has me.
Or Mom Miskin.
And all of a sudden it's like, it's David versus Goliath kind of thing. So you can do that kind of stuff. All right, everybody's shaking their head. Oh, poor Matt. He's going down, right?
I just want to see.
All right. What about an opponent's failure to call a witness? Can you comment on that? Yes, as long as you're not trying to shift the burden of proof. Okay. So you got to be careful about that as well. There are a lot of videos on YouTube you can watch in closing arguments. Might be a good thing to do. Whoever's doing the closing can watch some of those to kind of get a feel for that. They have a closing argument in O.J. Simpson trial, the Blagojevich trial, closing arguments on there. There's a mock murder trial on YouTube I ran across, closing argument. So give you some ideas there, maybe things you can look at. All right, so questions on closing arguments. Okay, we've got about a half an hour or so to divide up in our teams.
Can the
And-
prosecution speak with you, Your Honor?
Yeah, I'm going to speak to both teams here separately. So, let's divide up in our teams. I'm going to give you the names and contact information for the parties who are going to play your witnesses. Okay, and then we'll talk about let's see, we're going to do a direct exam. We'll talk about that in the exhibit. How we get that in? That shouldn't take very long to cover those. So let's divide up into our teams, and then I'll talk to the team independently.
I recorded the whole thing.